Good morning, everyone. I'm Michael Strom from Oasis Senior Advisors, and today I have the pleasure of interviewing Josh Ramirez from OC Elder Law in Fullerton, California. Josh, good morning.
Morning.
How are you?
Good. How are you doing?
I'm doing great.
Good.
So I was wondering, can you tell us a little bit about you, your background, and OC Elder Law?
Sure. So I've been fortunate enough to practice in elder law and estate planning exclusively. In law school, I was studying estate planning, taxes, and elder law. I then met my now partner, Marty Burbank, while at a Bible study through church. And ever since then, this is the only thing we've done together. And currently I live in Placentia with my wife and my son and a baby girl on the way.
Well, thank you, Josh, for that information on your background and the company. So I was wondering if you could speak to, for clients, what are the steps people should be taking prior to their passing?
Sure. So prior to when someone passes away, the first thing I recommend is making sure you have a good estate plan in place. That includes things like a trust, a will, a power of attorney, and an advance healthcare directive. Beyond that, we need to dive deeper into gathering your assets, a list for your children and other family members. We want to know your bank accounts, the numbers. We want to know how much is there. Where are they at? Are they at B of A or Wells Fargo? We want to know passwords to social media accounts and online banking in your computer. And finally, we want to know debt. Do we have credit cards and mortgages? So making a nice comprehensive list for your children and family really goes a long way.
Well, thank you, Josh, for all that information.
Sure.
So if someone does have all of their trusts and wills in place, what are the next steps?
Sure. So after someone passes with proper planning, we then turn to what's called trust administration. A lot of children come to me and ask me, what do I do? Doesn't matter how well your family gets along or if you hate each other. There are certain formalities that we have to take, including giving a legal notification of the passing and that there was a trust to all beneficiaries and heirs, giving a copy of the trust. We then have a waiting period of 120 days. During that time, that's when we're going to help you gather all the assets. That's when you're going to start thinking about cleaning and selling the home. And then after that 120 days passes, then we have to provide an accounting, down to the penny, to all beneficiaries on where money was spent. Was it spent at an accountant, a lawyer, for real estate commissions? How much did you as the trustee take as compensation? And finally, once we do all that, we issue checks, and then we can close the trust.
Well, excellent, Josh. So what happens when someone did all the proper planning, but the family just isn't getting along?
So unfortunately, not all families get along. There can be small rifts that lead to huge legal problems. So unfortunately, that phase, if we have to get that far, is what's called trust litigation or estate litigation. That's basically fighting. So we try our best to mediate with other attorneys involved and other family members to resolve our differences and move on with our lives. The last thing you want to do is have a lengthy court battle when you're also grieving the passing of a loved one. Unfortunately, mediation doesn't always work. Settlements don't always work, in which case we would have to go to court. And we would have to resolve our differences and leave it up to a judge. We try our best, and we're extremely successful, winning for our clients, making sure their rights are protected, they get their fair share, and most importantly, we carry out the decedent's intent. We want to make sure that their wishes are carried out after they pass.
Well, thank you, Josh. So could we talk a little bit about when a beneficiary is concerned about how a trustee is administering the estate?
Sure. So oftentimes what leads to litigation is beneficiaries complaining. The most common complaints I see is an accounting. Family assumes they get along or assumes when the trust says divide things equally, it's easy math. But people still are entitled to an accounting. That's the easiest way people drag us into court, is when trustees don't provide an accounting. Another thing people complain about very often is the trustee's fees. How much are you paying yourself to administer the estate? Oftentimes people don't pay themselves, and that's great. But sometimes you're taking a lot of time away from your family and your job. So it is fine to pay yourself. What's reasonable and what's fair, depending on your work, is what people argue about. So that's something that we can very easily mediate before it gets to litigation. Another thing people complain about is personal property. Mom or dad's stuff in their house. Who's going to get what? With proper planning, we can avoid those disputes. But again, with mediation and family meetings, we can determine who gets what and make sure things are fair. The last thing people complain about isn't so much how the trustee's handling the estate. It's really how did the estate come to be? What was the trust in place? Oftentimes, some beneficiaries who either got cut out or a little less than they thought they were going to get throw around words like elder abuse or undue influence. So if that's the case, any of those words arise, we need to immediately hire us so we can protect you, because we want to make sure you're not accused of these frivolous claims.
Well, thank you, Josh. So now can we talk about when after death someone actually did not do the proper planning, what happens?
Sure. So if someone didn't do the proper planning, unfortunately, we still have all the other issues I've talked about: accountings, litigation, dealing with personal property. But on top of all that, before we even get there, we have to deal with what's called probate. So probate's the process where we go to a judge, and a judge tells us, where does your stuff go and who's in charge? Sounds like a simple process, but unfortunately it's extremely lengthy, not uncommon to see at least a year and a half in court. And it's also extremely expensive. Just to give you a couple examples, a $750,000 estate is going to cost your beneficiaries $36,000 in attorney's fees and in executor fees. And it's not too uncommon to get $750,000. That's just a house here in Orange County. A $1.5 million estate is going to cost your beneficiaries $56,000. So those numbers are extremely high. So we want to do anything in our power to avoid that with proper planning.
Well, thank you, Josh, for all that excellent information. So if a client would like to call for a consultation or has questions, what's the best phone number to reach you at?
Sure. So 800-220-4205.
Excellent. And if someone would like to check out your website, what's the website location for you?
Sure. ocelderlaw.com. And with any questions, you can always email me directly, josh@ocelderlaw.com.
Excellent. Well, thank you for your time, Josh.
Thank you.
Bye, everybody.
Bye-bye.